one thing I was reflecting on, that the whole problem is the problem of abysmal ignorance and enormous fear, both conspiring with each other at different fora. That may be the government, that may be the policy planners, that may be the courts, that may be common people, because the corporations and all those who are working for them, they create a very strong veneer of ignorance about all these matters. I am glad that this organization is exploring, bringing out facts. That is very much needed. The other day I was talking with my grandchild, the possibility of someday making the people totally retarded. The people, those who are dispensable or disposable creatures in the market economy. And how that can be done? That can be done through food. You engineer the seeds. Genetic changes can be brought about over a period of time. And you make certain sections of people, certain areas of the globe, totally incapable of thinking at all. They can either get extinct or they become servile. Even that is possible. So where humanity is going to. Anyway, so far the courts are concerned, we had one tough problem. Government of India had sent a circular in 1951 to the United Nations Secretary General that in making treaties, the President is not under constitutional restraint. The President of India is free to enter into any type of treaty, and this WTO treaty belongs to that morbid type of treaty. And then we have the norms of international law. Whatever obligations are undertaken by the state, the government acting as its authorized agent, that is binding on that state. It means that it is binding on Parliament, it is binding on the Supreme Court, it is binding on judiciary, binding on people. This is their thinking, and this is a very, very dangerous thing. In WTO, Article 16.4 says that courts will ensure that they act in compatibility with the WTO obligations. This point has not been brought before the Supreme Court, but I think someday it will be brought before it. The petitioner asking whether it is Supreme Court or it has become a subordinate. Because as organ of the state, it is bound by the treaty. And the treaty makes it subservient to the WTO commitments. So someday the Supreme Court will have to take this view. When I was talking to Mr. Okala about these matters, considering the People's Commission report and all those, so this was our first point. What is the correct position under our Constitution? Is the President without constitutional restraints in entering into treaty? Can the Union of India enter into a treaty like this WTO treaty? So let the court speak on it. We tried 2-3 cases, but the court ignored those issues without saying anything at all. Then directly I moved a writ petition before the Supreme Court, challenging the WTO and certain tax treaties for these matters. So after 3-4 days of hearing, I was advised, as the issues were extremely complex, so better you first take the matter to the High Court. So I withdrew that writ petition, and it went to the High Court, it was argued. Now a good thing happened. High Court clearly said that all governmental actions are subject to constitutional restraints. So, on this view, the government's that circular to the UN Secretary General is wrong, though the government has not withdrawn it. I argued before the Supreme Court, then that was moved to Delhi High Court. The Delhi High Court decided that, in fact, before Delhi High Court, the government itself, I don't know how it happened, stated we are bound by all constitutional limitations. There is no extra constitutional power even at international plane. Now, if this be the position, then anything done under the WTO, which contravenes the Constitution anyway, is clearly unconstitutional and domestically non-operative. Whenever a treaty is violative of the Constitution, the courts refuse to give effect within the territory. Now this issue remained very controversial even in USA. In 1936, Justice Sutherland said that at international plane we are free to enter into any treaty and the government is bound, something like that. In 1952, Mr. Bricker moved an amendment that this was a silly thing to do. The Constitution should be amended, making all governmental acts, whether within the country or at international fora, subject to the constitutional limitations. That Bricker amendment failed because of Eisenhower's intervention. But 4 years thereafter, the US Supreme Court, Justice Black, gave a very beautiful judgment in Reed versus Covered that even the treaty-making powers are subject to constitutional limitation, and a particular treaty was invalidated by the court. But till this date in our country, nothing of that sort has happened. There is no decision in which a particular treaty has been invalidated on the ground of not conforming to the mandatory constitutional limitations. Friends, you know how the treaties are made. If laws are to be modified, we go to the parliament, a majority decision is needed. In certain cases, more than majority decisions are needed. And in certain cases, nothing can be done if they affect the basic structure. But then through treaty, which is done by the executive, as you saw in this, Mr. Mursali Malan went and signed there, and this bulky document of 2,000 pages, I'm sure nobody read it, and it was signed. Why I'm saying nobody read it? This is precisely happened when the Mughal emperor signed the Treaty of Allahabad in that fort after Battle of Buxar. The whole document was so bulky, he was just asked to sign it because someone had read and none had read it. So WTO treaty, otherwise that fat document is impossible for anybody to go through that way when till few months before the government's position was against those things. So now the position is, this is what the High Court has taken. Then I went to the Supreme Court. So what about the WTO treaty as done? You have decided on principle that all treaties are subject to constitutional restraints. This far is perfectly okay. This is a big advance. This goes against the government's own circular to the UN Secretary General. But then what about the specific treaty? The court didn't decide that, so just left it. Then I moved to the Supreme Court. The Supreme Court said very interesting thing, that was reported by the Times of India. So I will just read one paragraph, what the Times of India had reported. This is, I felt the High Court did not decide some of the core issues. I filed a special leave petition before the Supreme Court. I argued the matter on August 16, 2010. The Times of India, August 17, 2010 made some insightful comments under the suggestive title, Centre's treaty-making power must conform to the Constitution. Super. This is as the press reported it. The comment I would have made on the observation of the Supreme Court had been insightfully made by the journalist who said, quote, a petitioner, Advocate Shivakant Jha, complained before the bench comprising Chief Justice Kapadia and S.S. Radhakrishnan that the executive was going ahead and signing a large number of multilateral treaties to fulfill the WTO obligations and was refusing to adhere to constitutional provisions. When he argued that Delhi High Court had dismissed the petition on the ground that the treaty-making power of the executive was not subject to constitutional framework, the bench said. Because the court didn't catch, but anyway, what the bench says is important. Who said it is not? If you show us that a certain provision was a breach of the Constitution, certainly the apex court can examine it. Such treaties which violate the basic structure of the Constitution will be struck down. This is already stated in the High Court statute. So this was the comment of Chief Justice on my special leave petition. So I felt that at least there is some further development. Then the press
just if I could ask you to speak up.
Yes. Yes, I could. Though the court didn't entertain the petition, it surely showed a shift in the approach of scrutinizing the constitutional validity of the multilateral and bilateral agreements. Now this is the position. We can challenge the WTO treaty whenever it is appropriate. In fact, I have certain ideas. On this that issue, if some good documented something can be made out by Navdanya so that we can prove before the court of law from legalistic perspective that what is the dimension of genocide and what is the impact on human rights, on the fundamental rights, on the concept of democracy, the basic structure, so that more focused, because we have many points on this, but this is one of them. So from today's deliberation, we'll try to gather something. What were? Thanks.
Thank you so much, Jha Saab. And especially for our young people,